The number one challenge that industry is faced with today is what we call legacy lawsuits. Unfortunately, our judicial system in Louisiana is one of the worst in the entire country. We're 49th in judges' competency, we're 49th in jury fairness, and I can go on down the list. Consequently, our industry is the target of a lot of lawsuits that we call legacy because they're suing us for things that we did that were legal back in 1910 and 1920 and 1930. So it's a huge problem. And today we're going to have Dr. David Dismukes with the LSU Center for Energy Studies that's going to give a presentation on it and show the economic impact. But it's in the billions of dollars, and a lot of jobs have been lost because of the legal system and climate that we have here in Louisiana.
What kind of an impact economically has this had on jobs in Louisiana?
Well, on the study that we did, we figured that there was about as much as 1,200 drilling wells that had been lost as a consequence of this activity, probably as much as 6.7 billion in expenditures associated with that activity, maybe as much as 10 billion in economic activity overall when you count for the multiplier impacts of that activity, maybe as much as 30,000 in employment opportunities over about an 8-year period. So certainly a significant impact overall on drilling activity.
How would you characterize the impact of legacy lawsuits on Louisiana?
Well, it's certainly been significant. It's in some years, particularly in '05 and '06 and '07, some of our estimates were that it was as much as about a quarter of the activity. It could have been higher as a consequence of that actual the lawsuit activity.
What about lost tax revenue as a result of legacy lawsuits?
Well, there's certainly a lot of lost tax revenues associated with all that economic activity that I talked about before. We didn't go in and explicitly detail a lot of those tax implications, but I think one of the things that I talk about in the report that is concerned us, and one of the reasons why we were looking at it, has been the impact that this may have longer run and down the road for our state mineral revenues. As that drilling activity starts to slow down, new wells don't come online, production starts to slow, and mineral revenues as a consequence of that activity start to go down as well. So it's certainly the really motivating factor for having looked at this study to begin with.
Would you describe these as frivolous lawsuits and lawsuit abuse?
Absolutely they are. The vast majority of them are. We have a system in place in Louisiana. If a landowner has a complaint against the oil and gas industry, and by no means are we perfect, and if they do, they can go to the Louisiana Office of Conservation and file a complaint, and the Commissioner of Conservation will then send a crew out, take a look at it, and can at that time issue a compliance order to have it cleaned up.
Have there been examples that come to mind of more or less outrageous settlements that were reached in comparison to the actual cost of cleanup?
Oh yeah, the one case that started all of the legacy lawsuit issue was a case called the Cabello case, where the landowner ended up getting close to $73 million on a piece of property that had a value of $108,000, and the trial lawyers also got out of that about $8 or $9 million. And when you get that kind of settlement for something that merely $108,000 piece of property, then that's like throwing blood into the water, and the sharks start swimming, and there's more and more people looking at enriching themselves on the back of the industry.
Now, let me talk to you about an issue that I'm sure many of you are familiar with, legacy lawsuits. As I started taking a look at this particular issue, looking at the pleadings, looking at the history of how this current issue developed from the Supreme Court decision in Louisiana to the legislative achievements, you know, I've been working on tort reform for over 10 years, and I gotta say, wow, these guys really take the cake. They try to challenge the law in the Supreme Court based on constitutional concerns. They lose. Now they're circumventing the procedures by which you have this feasibility study hearing, which I understand is really the purpose of this legislation, Act 312. And this is indicative of a trend that I think feeds into, well, you know, it's a feeding frenzy, but it's also there to extort money out of companies. And it really is a job-creating issue. and frankly something that we are concerned about at the U.S. Chamber of Commerce. We look forward to working with our allies here on the ground as the Louisiana legislature convenes in a little over 2 weeks. We think that good common sense legislation to address some of these procedural gaming tactics must be addressed. Because when it comes to the energy policy of this country generally, we should not be stunting or thwarting domestic energy production through these types of frivolous lawsuits, especially when the state legislature and the state of Louisiana, Governor Blanco, all established a policy, a balanced policy, that these cases could be addressed through a certain procedural pathway. That does involve the courts, that does involve the administrative regulators here in the state, and is very sensible. But unfortunately, a handful of plaintiffs' firms in this state are looking at this from a very, very different perspective, and that is, unfortunately, about making money. Today, ILR will be releasing a study. It is called The Plaintiff's Bar Goes Digital, an analysis of the digital marketing efforts of plaintiffs' attorneys and litigation firms. It's going to be, I think, released sometime this afternoon. But the study finds that the plaintiff's bar is funneling millions and millions of dollars into internet advertising, social media, and search engines. The online marketing tactics of the trial lawyers show that they are the most sophisticated and it is the most expensive. Indeed, their tactics rival those in the pornography industry. And that is something that should tell you something. The study estimates that in a given 12-month period, major plaintiffs' firms spent more than $50 million just on Google keyword ads. Let me repeat that. $50 million, over $50 million by plaintiffs' lawyers just to advertise on Google. So if you type in a certain keyword, let's say asbestos or mesothelioma or hip replacement surgeries, that in and of itself will lead you to a banner ad or to search terms that will give you some content from the trial lawyers. To give you some perspective of this, you'll see how the ads compare from the trial lawyers. To the farthest left, the Ford Motor Company spent $2 million promoting their Ford Mustang. Next to that, the Obama campaign in 2008, perhaps the most significant digital campaign, $16 million for the entire campaign for Google advertising. And then for you with iPads and iPhones, the Apple Corporation has spent a little over $20 million. But the trial lawyers have spent $52.6 million. In fact, one law firm from the Houston area is responsible for $16.6 million of that $52 million figure. Any guess as to which law firm that is? Danziger and Delano. They're a big, what we call harvesting or a feeder firm. These guys don't even go to court. They find the clients and they do fee-sharing agreements with the actual Barron and Buds and these other firms that do the litigation. It's an industry, and they are actively looking for anyone with any remote exposure to asbestos, someone who's taken a drug, someone who's been foreclosed on. I mean, it really is quite pervasive. This next slide will probably show you why this total figure of $52 million is so high. These are some of the most expensive keywords in the entire Google system. Mesothelioma, per click, is $84.08. So if you are on your iPads and your iPhones and you go onto Google and you click mesothelioma, you've just cost Delano and Danziger $84. And if you get bored with my speech, continue doing it, and by the time it's done, it'll cost them about $10,000 to $15,000. So that's a way to contribute. And this is just online spending. As viewers of daytime, late night TV are aware, you see the heavy dose of ads cycling. I watch Fox News, and I can't get away from a single ad in a period of 15 minutes. In 2010 alone, the trial bar spent a whopping $844 million. I was actually surprised that I didn't see him advertise during the Super Bowl, because given the amount of resources that they have, it is pretty pervasive. And of course, let's not forget about social media. Facebook, YouTube, Twitter, Wikipedia, these guys are all over it. They're pushing their content, they're using very sophisticated search engines to find clients, to make sure that their story is heard, and to basically build and advance their business model. Ladies and gentlemen, the trial lawyers have fully adjusted to the 21st century. They are aggressive, They are smart, they are tactical, and they are out there, considerably out there. You know, I went to law school believing in the principles of justice. It's a noble profession. Harper Lee from To Kill a Mockingbird was the image I had. Now, it's been replaced with LA Law, Ally McBeal, the Lincoln Lawyer, and it's a trend that I think really does bear some consideration, because once the legal profession moves further and further away from securing justice for people who are sick, it becomes an unsustainable proposition that does merit some serious community scrutiny from the business community. And I guess that's why I became a lobbyist. The second emerging issue that I'd like to discuss, and I think we heard tones of this with Gigi's story about the EPA, is enforcement overreach. Now, normally we do talk about trial lawyers, but there has come an unholy alliance between private plaintiffs' lawyers and certain state enforcement actors, state attorneys general, the Department of Justice, the Securities and Exchange Commission. These are just a sampling of some of the issues that we are tracking and are extremely concerned about. The Foreign Corrupt Practices Act is an anti-bribery statute from 1977. For those of you in this room who have had to try and understand and comply with this, if you have any presence internationally, it is something that really merits some serious consideration. Passed in 1977 as part of a post-Watergate era law, and it's a good law. We don't want to have corrupt foreign markets. Unfortunately, the enforcement trajectory under the FCPA has gotten so onerous that in 2010 alone, the Department of Justice collected $1.8 billion in private settlement amounts and proceeds from virtually every industry sector of the United States: the pharmaceutical industry, the tech industry, the energy industry. Anybody who does business internationally, you've got to watch out for this FCPA. And the Justice Department, it's almost, they're just completely out of control in terms of their prosecutorial discretion. They are stretching the original meaning of the law beyond the intent of Congress, and unfortunately, we don't see any end in sight. They're emboldened by these settlements. And I don't know of a single company that's willing to roll the dice and risk an indictment. We saw what happened with Arthur Andersen, and so what's happening now? Everyone is settling. The Department of Justice comes in and says, we think you violated the FCPA because of A, B, C, and D. And you say, that's ridiculous. This person isn't even a foreign official. We all know who a foreign official is. It's a defense secretary from another country. If you give them bags of money, sure, that violates the FCPA. How about a nurse at a state-run hospital? How about a vendor whose brother or mother is a foreign official? These are all questions that, in real time, are wrapping companies around the axle because they don't understand how to comply with this particular law. It's a problem and something that the U.S. Chamber has taken some aggressive steps to address. We are pushing back against the Department of Justice. We are asking for legislation as well as more clarity and guidance from the Department of Justice and the SEC. The False Claims Act is also a federal law which stands for a very good proposition. You shouldn't submit a false claim to the federal government. But unfortunately, it has become another enforcement tool, which has really been used as a blunt instrument against the business community. These cases are driven by trial lawyers. If you go on to if you Google False Claims Act, I'm sure you'll find some ads from trial lawyer firms looking for so-called key tam or whistleblower plaintiffs to advance these cases. It's a pervasive industry and something that, again, is of particular concern, and we are pushing back. And then I mentioned the state attorneys generals. Ever since the 90s, during the tobacco litigation, the state attorneys general, they've held a very close relationship, or at least some of them, with those in the plaintiff's bar, where the state attorneys general, they hire plaintiff's bar individuals to go out and prosecute or enforce consumer protection laws, State False Claims Act, and they recover contingency fees as part of this type of relationship. And something that is very problematic for a tremendous amount of those in the business community, and again, something that we are trying to get more transparency and accountability with through state legislation.
Legacy lawsuits are one of the critical issues facing the industry, and if we can resolve those issues, I think we'll have a lot of industry coming back into Louisiana. The legacy lawsuits are just something that's lurking behind every corner, and is so unfair to industry. Trial lawyers are using this to line their pockets. Companies and individuals are buying properties with the idea of looking for some reason to sue oil companies. They're looking for deep pockets, and they're harming Louisiana while they're harming the oil companies.
My name is Mary Shattuck Jones. I was previously attorney for Global Industries, a company in Louisiana, and we underwent a Foreign Corrupt Practices Act investigation in Washington with the DOJ and the SEC and the FBI. And we were talking about today at LOGA the impact of the Foreign Corrupt Practices Act on oil and gas companies in this area. We had an experience where we were able to eventually not have any action taken against the company, but in order to defend it, we spent over $12 million in outside attorney's fees. And what we're trying to do today is to bring things to the industry, bring events, bring legislative matters to the industry so that we can together try to make an impact and fight those items such as the Foreign Corrupt Practices Act that we think really are being overreaching and not being beneficial to the business community.
You can certainly go to our website or just call our office. We certainly are there for our members and other people that want to ask any questions and need some things answered for them.